Good afternoon, everyone. This is Tracy Wolf. I'm a partner at Husch Blackwell. I'm a Texas Board Certified Labor and Employment Attorney, part of Husch Blackwell's Labor and Employment Practice Group. Welcome today to our webinar. Before we begin, I would like to cover a few housekeeping items. At the top of your audience console, there are multiple application buttons for your use during today's program. If you have any questions during the webcast, please submit via the question box. We will try to answer questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program's material folder at the top of your screen. This program has been approved for legal education hours and HRCI and SHRM hours. For live attendees, report your hours by clicking on the Continuing Education Sign-In button at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of today's program, be sure to complete your short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping. Now let's get started with our program. Today presenting with me is Sam Mitchell. Sam is a partner in our Chicago office. He's a seasoned litigator with significant experience representing both plaintiffs and defendants in a wide range of high-stakes, complex commercial litigation disputes, employment litigation, business torts, breach of contract, trade secret misappropriation, and other areas related to business. He also handles appeals. Also, I must say this about Sam. He's been known to occasionally be quoted in Law 360. So hopefully your paths have crossed with Sam already. We're going to start off with a difficult topic that is of interest to most right now due to the recent landmark decision coming out of the United States Supreme Court. Today's agenda, we are going to define reverse discrimination. Also, we're going to provide a historical view of the background circumstances test and the circuit split prior to the Ames decision. We're going to give background and analysis of the Ames decision that will be handled by Sam. He's going to tell you everything he knows about Ames and what it may mean for employees and employers moving forward. I will discuss the EEOC enforcement policies and our current administration. We're going to talk a little about textual approaches and atextual approaches to Supreme Court decisions and possible future challenges to McDonnell Douglas, which for our employment lawyers in the group will probably be quite exciting. Those of us who have been practicing any significant amount of time, that's kind of a term that goes along with many of our employment cases and something we're used to employing. We're also going to briefly discuss some executive orders coming out of this administration, specifically one that is the rescission of affirmative action requirements. And we're going to talk a little bit about the changing legal landscape and the future of DEI programs and preferences. Just for clarification before we get started, I want to make sure that everyone knows what this is essentially not. And in this presentation, we're going to examine and discuss the current status of the law and the recent Ames decision and the future of DEI. It's our intent to provide information. We're not here to provide our opinions, political or otherwise. We're going to provide information. And I'm getting a note that there's an issue with sound. I think there might be a sound issue. Okay. Thank you. I'm sorry about that. Sometimes technology gets in the way. As I was saying, we're not here to provide opinions today, political or otherwise. They will be not included as part of this presentation. Our topics are the landmark Ames decision, the unprecedented shifts in federal enforcement priorities under the current administration, and the heightened scrutiny and legal uncertainty for DEI programs. And with that, I am going to turn it over to my partner, Sam.
Okay, thank you, Tracy, for that introduction. Hello, everyone. My name is Sam Mitchell. I'm an employment litigation partner, like Tracy said, in our Chicago office. I represent employers in all kinds of litigation, including Title VII, and I'm regularly advising clients on evolving workplace laws. The employment discrimination area is certainly one that has evolved significantly too, so I'm very excited to be here today. We have a lot to cover, so let's get after it. We're going to start with the basics. Just generally speaking, what do we mean by reverse discrimination? It's a popular phrase. We read it, we say it, we talk about it, but what does it actually mean? As it turns out, the term is not so easy to define. If you pick up your nearest Merriam-Webster dictionary, you're going to see this definition: discrimination against whites or males as in employment or education. Here, the term is expressly defined in terms of race, specifically white, and gender, specifically male. But I think, as we'll see and discuss shortly, this definition isn't complete. The plaintiff in the Ames case that we'll discuss shortly was a white woman who alleged that she was discriminated against on the basis of her sexual orientation. Black's Law Dictionary, for the lawyers on the line, we often cite the Black's Law Dictionary as our favorite in briefs and such, defines reverse discrimination as preferential treatment of minorities, especially through affirmative action programs, in a way that adversely affects members of a majority group, specifically the practice of giving unfair treatment to a group of people who have traditionally been privileged in an attempt to be fair to the group of people unfairly treated in the past. This definition is certainly more precise, but arguably still leaves some room for interpretation. And therein lies sort of the controversy with the term reverse discrimination generally. There's no definition that satisfies everyone under all conditions. In fact, some people don't even recognize it as a true form of discrimination because it does not involve the systemic power imbalances associated with what I think many people would call traditional discrimination. Others argue that the term is nebulous as to the precise meanings of majority and minority. Whatever jurisdiction you're in, or if you're in a city or a state, whatever jurisdiction you're looking at, the actual majority versus minority might be different based on where you are. So the court in Ames, perhaps wisely, didn't even try to define reverse discrimination. In fact, the term isn't even mentioned at all in the opinion. So where does reverse discrimination arise? Typically, we're going to see it in the employment or education settings, decisions in employment, such as promotions and hiring, and also educations in terms of admissions, et cetera, when a majority group member is perhaps more qualified, but the decision is made to favor a minority group. Of course, there are any number of examples that we can provide on what reverse discrimination, fact pattern-wise, what they look like. Here are a few non-exhaustive examples. A company promoting a female, minority, or an LGBTQ plus individual over an allegedly, very important, allegedly more qualified white heterosexual or majority group individual. This also arises, reverse discrimination also arises in the affirmative action context. Many of you will be familiar with the Supreme Court's 2023 decision, Students for Fair Admission versus Harvard College. In that case, the court ruled that Harvard's race-conscious admissions program violated the Equal Protection Clause of the 14th Amendment. The plaintiffs had argued that Harvard's admission process discriminated against Asian American and white applicants, favoring underrepresented minorities. This is a reverse discrimination argument, in effect, because it asserts that efforts to promote diversity can result in unfair treatment of non-minority individuals. But of course, today we're focusing on Title VII and the employment context. So we are going to be talking today about Title VII. Title VII, as I'm certain you all know, prohibits discrimination in employment because of such individuals' race, color, religion, sex, or national origin. Bars discrimination in the terms and conditions of employment. We have here, and we are making this available to you, the slides here. So here's the actual text of Title VII that is describing disparate treatment under the law. So that's treating two people differently, two people of different race, color, religion, sex, or national origin differently, and that is disparate treatment. This is disparate impact, this next slide. Disparate impact refers to a policy or practice that appears facially neutral, but disproportionately disadvantages a protected group, even without intentional discriminatory intent. And we're going to be talking mostly today about disparate treatment, which was the prior slide. Disparate impact is also very much in the news right now. There's been an executive order, for example, from the Trump administration directing agencies not to enforce disparate impact or claims on the basis of disparate impact. So there is much to be said about disparate impact, but today we're going to be focusing on disparate treatment. So Title VII makes workplace discrimination unlawful on those protected bases. The question then becomes, how do we analyze, or how do the courts analyze whether such discrimination occurred? When there is direct evidence of discrimination, like an express statement or so, that's a more straightforward call. But often, and most of the time, there is not going to be direct evidence of discrimination. There's only going to be circumstantial or indirect evidence that suggests through inference that discrimination occurred. And that is where enter McDonnell-Douglas. The test dating to the 1973 case McDonnell-Douglas Court versus Green. This is a judge-made legal framework that is used to analyze discrimination claims when there's no direct bias, no direct evidence of bias. It's essentially a burden-shifting process. The employee goes first. The employee must present initial evidence suggesting that discrimination occurred, raising that inference. Importantly, McDonnell-Douglas called this step, quote, not onerous. It's not supposed to be a particularly big step for the employee to satisfy. It's supposed to be just a prima facie case that the employee needs to submit evidence to achieve. Then next goes the employer. The employer must articulate a legitimate non-discriminatory reason for the action. And then if the employer does so, then the ball is passed back to the employee, and the employee can then try to show that the employer's stated reason is a pretext for discrimination. And very importantly, because this is language that is straight out of the Ames case. It's straight out of McDonnell-Douglas, but it was repeated in the Ames case, that the purpose of McDonnell-Douglas is designed to bring litigants in the court expeditiously and fairly to the ultimate question. In other words, whether discrimination actually occurred. So in terms of the general framework for evaluating discrimination claims where there is no direct evidence, the McDonnell-Douglas test has been around for over 50 years. And that has been, often the case that attorneys are citing and briefing, and we arrange our legal arguments and facts around those three steps, those three elements, and we're all very familiar with them. But some courts, for many years, some courts added an extra step when the plaintiff was a member of a majority group alleging reverse discrimination. This additional requirement became known as the background circumstances rule, and it meant that majority group plaintiffs had to provide special evidence suggesting their employer was the rare case that discriminated against the majority. The case originated in a DC Circuit case called Parker in 1981. So it's another judge-made law, or test rather. And it was articulated in a case where a white male employee claimed he was denied advancement due to the employer's affirmative action efforts. The DC Circuit had reasoned that since discrimination against majority groups was seen as less common, these plaintiffs should provide, that is, majority group plaintiffs, should provide extra evidence or background circumstances to show that their employer might actually discriminate against them on the basis of their majority characteristic. This is straight from the Parker decision and how they described it. Majority plaintiffs, in addition to establishing a prima facie case of discrimination under the McDonnell Douglas framework. So again, prima facie case, that's the step one of the three-step process. The court in Parker was saying, okay, if you're a majority group plaintiff, in addition to satisfy your prima facie case under that first step, you need to prove or show something in addition to, some additional background circumstances to support the suspicion that the defendant is the unusual employer who discriminates against the majority. And that word that we have in bold there, unusual, is really the important word, because how do you determine if your employer is the unusual employer who discriminates against the majority? Well, there are a few ways, and there are a few ways, but I wouldn't maybe call these common so much as these are just ways that we have seen courts sort of permitting majority group plaintiffs who are able to show this type of evidence to make that extra showing under the background circumstances rule. It's actually in practice very difficult for majority group plaintiffs to do that. But some ways that that courts would find that the rule is satisfied, demonstrating that the decision maker is a member of the minority group, and that may have influenced the decision. It's not, of course, enough to just prove that the decision maker was a member of the minority group. It would be required for you to show evidence for the employee to show evidence that the decision maker actually, that somehow entered his or her calculus in making the decision. Another way, providing statistical evidence of a pattern of discrimination against majority group employees. Again, it's not necessarily a straightforward analysis. You're getting just more of a mathematical analysis. So it requires, again, an extra layer, an extra amount of evidence to actually show that a statistical pattern exists. And then, of course, a plaintiff could point to past incidents or policies indicating biases against the majority group. Now, in practice, these are the 5 circuits that adopted the background circumstances rule. The 6th Circuit, based in Ohio, the 7th Circuit, based here in Chicago, where I am, the 8th Circuit, which is the middle of the country from Minnesota south through Missouri, the 10th Circuit out in Colorado, I believe, Denver is its seat, and then the DC Circuit. So geographically, it's a pretty significant part of the United States. It's practically the entire Midwest, and then some, out west. But this obviously suggests a circuit split, right? So we have half of the circuits, or a little under half of the circuits, saying that majority group plaintiffs, in order for them to show that they are the victim of a discriminatory action, had to adduce the extra evidence to pass that evidentiary threshold to get past summary judgment. And the consequence, of course, was that it was more difficult for some people to advance their majority group claims because of the background circumstances test. But in other jurisdictions, those other majority group plaintiffs in other jurisdictions didn't have to meet the same evidentiary threshold, which obviously creates a rift throughout the country. And so this leads us to the case of the hour, Ames versus Ohio Department of Youth Services. This is a decision that was just handed down a month ago, a little less than a month ago. By far the most important part of Ames on this slide, most important information on this slide, is that it was a unanimous decision. It wasn't a 9 justices agreeing in the result with concurrences, like I concur in the judgment, but for all these other reasons. That happens quite a lot on our current Supreme Court. This was a 9-0 decision, all justices signing on, written by Justice Jackson. And then a concurrence was also written by Justice Thomas and joined by Neil Gorsuch. And we'll discuss the concurrence here in a moment. But I think that unanimity is very important to consider when we talk about Ames and how the court was really thinking as one in terms of of the background circumstances rule. So what the court did in Ames is really significant for employers and employees alike. The decision levels the playing field, so to speak. The result is that all Title VII discrimination claims, regardless of whether they're brought by members of a minority or majority group, are judged by the same legal standard. So as a practical matter, this means that the background circumstances rule is now gone everywhere in the country. All 5 of those jurisdictions, I'm going backwards. In all 5 of these jurisdictions now, the background circumstances test is or should be eliminated. It's no longer deemed consistent with Title VII. I'm going to catch up here and explain why. Well, let me first give you the facts. The plaintiff in this case, a woman named Marlene Ames, a straight heterosexual woman. Ms. Ames had been with the Ohio Department of Youth Services for something like 15 years before this allegedly discriminatory action was first experienced or first occurred. Ames applied for a management position. She was a program administrator in 2019, and then she applied for a management position and ultimately was not selected. The position was given to a lesbian woman. Shortly after, Ames was demoted from her program administrator role. So this was the role that she had while she was applying to that management position. She didn't get the management position. Then she was in her program administrator role position and was demoted from that position to another lower paying position. And then a gay man was hired to replace her in that program administrator role. So Ames filed a Title VII lawsuit arguing sexual orientation discrimination, which of course, as many of you know on the line today, is a protected class post-Bostock. And Bostock is, of course, the court's 2020 decision holding that Title VII's prohibition on discrimination because of sex includes discrimination based on sexual orientation and gender identity. So those are the facts of the case. The lower court rulings in Ames, they read like a very faithful adaptation of then Sixth Circuit law. The district court dismissed Ames's claim at summary judgment, holding that Ames, as a majority group member, had failed to show the background circumstances test. Of course, where this Ames is the case was venued, it was in Ohio, which is in the Sixth Circuit, one of the circuits that had adopted the background circumstances rule. And so the lower court just said, you failed to adduce the evidence that you needed to show that your employer was the, quote, unusual one, to discriminate against a majority group plaintiff. The Sixth Circuit, on appeal, affirmed that dismissal and reiterated that the majority group plaintiffs must provide extra evidence beyond the standard Title VII prima facie case. So that's step one. Again, we're talking about the step one in the McDonnell-Douglas analysis, and concluded that Ames had failed to adduce that evidence to show sufficient background circumstances that her employer was the unusual, quote unquote, employer to discriminate against a majority group employee. This leads to the Ames decision. And that question at the top is exactly the question that was certified to the court and that the court considered in this Ames case. Whether Title VII imposes a heightened evidentiary standard on majority group plaintiffs. Ames had argued that Title VII protects all individuals. If you would go back to the text of Title VII that we reviewed earlier in the slide, the operative word there is, according to Ames, is the word individual. It protects all individuals from workplace discrimination, regardless of majority or minority status. To that end, she claimed that the Sixth Circuit ruling contradicted both the statute's text and the Supreme Court precedent requiring equal treatment for all plaintiffs, regardless of majority and minority statuses. Interestingly, Ohio all but conceded at oral argument that Title VII's prima facie burden is the same for majority and minority group plaintiffs and does not actually justify a heightened evidentiary standard for majority group plaintiffs. And you might be thinking, well, then what what was this case actually, about? Like, what were they contesting? Ohio, during oral argument, argued that the background circumstances rule is not so much imposing a higher or heightened evidentiary standard on majority group plaintiffs. It's just another way of assessing whether an employment decision was based on a protected characteristic. It's not actually an added burden. That argument failed to gain precisely zero traction with any of the justices. In fact, at oral argument, Justice Gorsuch even commented that there appeared to be, quote, radical agreement between the parties as to the question of whether Title VII imposes a heightened evidentiary standard on majority group plaintiffs. The unanimous court then, in its opinion, criticized this argument as missing the mark by a mile. So when we look at the court's unanimous holding, the court held that the background circumstances rule cannot be squared with either the text of Title VII or the Supreme Court's precedents, essentially Ames's arguments. The court explains this outcome in two ways. The first is very much a straightforward textualist argument. The Supreme Court found that Title VII's language is clear. It protects any individual, so going back to the statutory text, and draws no distinctions. This is directly from the opinion. Quote, draws no distinctions between majority group plaintiffs and minority group plaintiffs. Emphasizing that discrimination is unlawful regardless of who is targeted. There's, according to the Supreme Court, no legal basis for treating claims differently based on the group's protected status. The court, I mean, that's enough to resolve the case, but the court also provided a secondary reason for that, for its holding. And the second reason was that the background circumstances test is inconsistent with the court's repeated instructions. The court in various cases, the progeny to McDonnell Douglas, has repeatedly stated that McDonnell Douglas is meant to be flexible. It's not rigid, it's not one size fits all. The facts and context of each case matter and may call for different types of evidence at that first step in the McDonnell Douglas analysis rather than a strict formulaic approach. So the court looked at, with that in mind, the court looked at the background circumstances rule and said, well, that rule ignores this principle by always requiring, that's the key, majority group plaintiffs to meet a unique heightened evidentiary burden, like providing statistical data or details about the decision maker's identity, regardless of the facts. To the court, that did not square with its repeated instructions to all to interpret McDonnell Douglas and apply it flexibly. So the actual majority group opinion is rather short. I don't know how many pages it is, but it's a quick read. And it really is matter of fact in how it describes its holding and its reasoning why. Another interesting, I mean, there's so many interesting things with this case and this topic, obviously, but it was 9-0 decision, of course. There was a concurring opinion from Justice Clarence Thomas. Justice Thomas highlights, in his concurring opinion, highlighted concerns about judge-made rules in employment law. And I would note that so does Justice Jackson writing on behalf of the majority. The majority's opinion identifies the background circumstances rule as a judge-made test of sorts, and it's not it being a judge-made test. It was inconsistent with the statutory text of Title VII. Justice Thomas, joined by Justice Gorsuch, is taking it a step further. He's actually saying that McDonnell Douglas, probably can't find any employment lawyer on earth who doesn't know what the McDonnell Douglas test is. But he's saying that the McDonnell Douglas test itself was made out of whole cloth. That's a quote, with no basis in Title VII's text whatsoever. In fact, Thomas notes that the Supreme Court has never expressly endorsed McDonnell Douglas in a summary judgment case. In fact, it has only once dealt with McDonnell Douglas on summary judgment and determined that McDonnell Douglas didn't apply. That was a case involving mixed motives, which was an exception, which is a set of facts that's an exception to the McDonnell Douglas framework. Thomas, further argued that it creates confusion. I think that is something that a lot of people can empathize with. It creates artificial distinctions between direct and circumstantial evidence. Again, that's going back to our earlier comments about how if there's direct evidence of discrimination, it's a pretty straightforward analysis versus indirect or circumstantial evidence. Justice Thomas is saying evidence is evidence, direct, circumstantial, or otherwise. It's all evidence that plaintiffs should be able to put forth as their reasoning for why a discriminatory act happened.
Sam, I want to jump in for just a second and ask a question on this concurrence, because this is fascinating. And Justice Thomas, it seems that do you think he's issuing an invitation for future cases challenging McDonnell Douglas? And second part of that question, what would an employment lawyer that's been practicing, say, over 20 years do without McDonnell Douglas? It's kind of, our go-to. What are your thoughts?
Well, I mean, taking the second question first, there might be a lot of retirements, a lot of people just saying like, I'm out. But I think importantly, there were only two justices who signed on to this concurrent opinion, Justice Thomas and Justice Gorsuch. It takes 4 justices to approve a cert on an issue to the Supreme Court. So right now, there are only Justice Gorsuch agrees with Justice Thomas or is willing to sign on to the concurrent opinion. So is it a invitation by Justice Thomas? I think so. Yeah, I think absolutely it is. And I think we see a lot of that telegraphing on today's court through their concurring opinions and their dissenting opinions. Speaking directly to the bar or to employees or to employers, the courts. I think it's very possible that we're going to see some litigation now rise up and try to defeat McDonnell Douglas or to find McDonnell Douglas as inconsistent with Title VII, which is an interesting, as an employment defense attorney, that's an interesting. That would be an interesting thing to happen because it essentially would allow more plaintiffs to pursue discrimination claims. That's what the effect would be. More cases would be able to survive discrimination survive summary judgment because a plaintiff could still prevail if their evidence raises a reasonable inference of discrimination, even if they cannot satisfy the framework's 3 steps. So, I mean, that's the sort of the irony of what Justice Thomas is saying here. If we get rid of McDonnell Douglas, we're actually allowing more employees to bring their claims and bring them past the summary judgment stage. So thanks, Tracy, for that. We'll have to keep an eye on that. I'm sure we're going to see people try to challenge McDonnell Douglas now. Just a quick note on textual versus atextual. I mean, if you polled all 9 justices, all 9 of them would raise their hands and say that they're textualists. I'm positive the vast majority of judges too would do so. So textualism is simply just interpreting law focused on the actual words used in the statute. This atextual approach, it's again, all the justices would certainly subscribe to textualism. It's really more of a question of are they looking beyond the text of the statute, and obviously in this case, unanimous decision. The court looked directly to the text of the statute, and then Justice Thomas writes in who is very much an originalist in his interpretation of the Constitution and textualist in terms of how he looks at the laws, is saying, well, if we're going to get rid of the background circumstances rule, we might as well get rid of McDonnell Douglas too, because that too is a judge-made rule that has no actual basis in Title VII. So we'll see what happens on that front. It's going to be exciting to keep an eye out for it. So just a few notes before I turn it over to Tracy, what Ames means for employers. The headline, there's a uniform standard. All Title VII discrimination cases now proceed under a single consistent legal framework nationwide. We expect to see more quote unquote reverse discrimination claims to be filed and to survive dismissal attempts, especially in those 5 circuits that had formerly adopted the background circumstances rule, pretty much the entire Midwest and then out west to the Colorado area. We're also anticipating heightened scrutiny of DEI efforts, affirmative action, and diversity-related employment practices. likely to face more legal and regulatory review, and Anne's going to comment on that now. So I'm happy to turn it over to her for her part of the presentation.
Good afternoon. Now I'm going to talk a little bit about the EEOC implications and suggestions moving forward. Before moving on, though, I've seen some great questions, and I thank you all for submitting those. Because we're a little bit on a short time frame, I don't know that we're going to be able to get to all of them, but one I wanted to point out, the question about what's a majority group? Majority of what? Society, the workplace? That is precisely one of the issues, describing what qualifies as a majority, and I think that's part of the ambiguity, which in part led to Ames and this determination of what is actually textually in Title VII. I think going beyond that, Title VII does not define majority. That word's nowhere in the statute itself. And I think that was kind of the point the Supreme Court is making. It's not going by the true wording and what Title VII what it actually says. And that's where problems arise. We get judge-made law and interpretation and tests that may or may not be able to determine what is a majority group. And that, right now, I think is an absolutely outstanding question. Wanted to start off by talking about enforcement and priorities. A lot has been changing with the EEOC, and I know since I started practicing, very different. I commonly visit their page, and I think that's a really healthy thing to do. I think one of the best places to start is the statement from the acting chair of the EEOC, Andrea Lucas. She released a statement the week that the Ames decision came out earlier this month. She applauded the U.S. Supreme Court and noted that the Supreme Court had resoundingly dispelled the common misnomer of reverse discrimination, making clear that discrimination on the basis of a protected characteristic is unlawful discrimination, no matter the identity of who engaged in the discrimination or which workers were harmed or benefited. I think that statement may address several of the questions I've seen coming through during Sam's portion of the presentation. So hopefully that does answer some to the best of I guess the EEOC's ability, or Ms. Lucas's. She further noted that the EEOC has taken a, quote, colorblind group neutral position for at least 50 years. The statement went on to talk about the background circumstances test, categorizing it as nonsensical, questioning the unusual employer portion of that test, which thought was really interesting, something that Sam had addressed in detail just a few minutes ago. But this last portion of her statement, I think it's very important to look at that, because I think that is kind of a glimpse into where we're looking in the future. This is what Ms. Lucas had to say. But a number of this nation's largest and most prestigious employers have overtly discriminated against those they deem members of so-called majority groups. American employers have long been obsessed with diversity, equity, and inclusion initiatives and affirmative action plans. Initiatives of this kind have often led to overt discrimination against those perceived to be in the majority. Under my leadership, the EEOC is committed to dismantling identity politics that have plagued our employment civil rights laws by dispelling the notion that only the right sort of plaintiff is protected by Title VII. In the wake of Ames, there can be no more confusion. I think that's very, very precisely states what the acting chair, who may be confirmed as the chair of the EEOC, how she views this decision and how the EEOC may respond. This is a particularly, I think, important part, probably the most important part of the statement given by Andrea Lucas. In closing, she said, thoughtful employers will take note and review their policies and ensure compliance with Title VII. Likewise, employees who have experienced DEI discrimination at work should be encouraged by the court's ruling. The EEOC stands ready to help employers comply with their obligations not to discriminate, but where necessary, the agency is also prepared to root out discrimination where it remains entrenched. So any question about the importance of Ames, I think is in part answered by the conclusion or the statement provided. Now, with regard to and I'm sorry, apparently I'm having a little bit of a technical issue. I'm confirming that there's no issue with my sound. Okay. I hope everybody can hear and see me. That's always annoying when you can't hear somebody. So my apologies. I hope everybody's hearing us okay. Let's talk about Ames in a little more depth because of the timing. We have a new administration, and while Ames was not, when the case was initially heard and was initially decided before going up to the, thank you, I see everybody saying we can hear and see you. Thank you, everybody. A lot of comments. I appreciate it. This was prior to the current administration, and the outcome is supports the focus of this administration, which is kind of interesting. The two, you know, are not really connected, but at the same time coincide and are representative of, it seems, where the current administration is directing employment litigation in the least. We also need to bear in mind that it aligns, the Ames decision aligns with the executive orders rescinding affirmative action requirements and targeting illegal DEI practices. Just a little bit of a refresher, and I won't go too deep into this. I know those who are lawyers already know this, and those who are not probably don't want to go into a lot of detail, but the EEOC is particularly important, and their views are important because all of the laws enforced by the EEOC, with a minor exception, require that complaining parties file a charge of discrimination with the EEOC prior to pursuing a lawsuit. Thus, the EEOC has the ability to look over any types of claims such as reverse discrimination. This is usually accomplished through filing a charge of discrimination. The EEOC has district and field offices. Parties can visit. They can also do it online. And as most of you probably know, many states and local jurisdictions have their own administrative agencies that are very similar to the EEOC in many ways. They enforce state and local laws. They're called Fair Employment Practices agencies. When you file a charge of discrimination with one of these FEPAs, usually it's considered automatically dual filed with the EEOC if federal law applies. So essentially, the EEOC is kind of a gatekeeper to litigation. They get to make a determination on the front side whether that's a topic or area that interests and whether or not it's something they want to pursue and file suit. In the event that they determine that they're not interested in taking that up, they issue what's called a right to sue letter to the charging party. And at that time, that person can proceed, a group of people, oftentimes there's more than one, can proceed with litigation through the court system. So this becomes very important. And I think that this is a great time for us to have a moment and take a poll. I'm going to give everyone a couple of minutes to answer this poll. A lot of this we're just very interested in as well. Has your company or organization received a notice of charge of discrimination or, quote, reverse discrimination? And I'll give everybody about 2 minutes to respond. And I've got while everyone's answering the poll question, I'll say I'm scrolling through questions. I think a lot of them are probably being answered. We're going to try to get to as many as we can. I think I've tried to address a couple. Lots of great questions. I can tell that everyone is concerned and engaged in this area of the law right now, and I think that's really important. All right, let me see. It seems like we have a lot of responses. We've seen some charge of discriminations. Okay, we have 12% coming in, 12.9% coming in at yes, 54.9 at no. Some, may not be in the know in their organization about that, but it's certainly something we've been talking with clients about and counseling about, and certainly something that is anticipated. I think that the landscape is going to change significantly. What better time to talk about the current EEOC landscape? These are, and I won't read, and I think most of you are probably familiar. I'm just going to kind of summarize what the priorities are. We know that we've seen comments from the acting chair, Andrea Lucas. She is quite open and definitely following the lead of the current administration. Things that have become important, anti-American discrimination. We're seeing DEI scrutinized, scaling back on LGBTQ protections. I know a couple months ago we did a presentation on that. Also, an increased focus on reverse discrimination. I think the Ames case is going to change a lot going forward. Right now, the EEOC, which typically has 5 commissioners, there are only 2, so they're not at quorum. We anticipate that a 3rd seat may be filled by pending Republican EEOC nominee Brittany Panucio, who is a Florida assistant U.S. attorney. I understand that a lot of her views are very compatible to those of Ms. Lucas. We've also seen the executive orders, and I know in our last presentation we talked at detail. We're going to talk about a few of them at the end. Now we've got recognizing only 2 sexes, and we've got federal agencies have been directed to stop using the disparate impact theory in all contexts. So we are seeing a shift, dropping transgender discrimination cases, removing their AI guidance, and really the EEOC has started to pause or reverse a lot of the Biden era initiatives. We're anticipating a possible uptick in litigation and amicus briefs once a quorum is restored, but things have been a little bit different with the EEOC recently. And I'll skip and let's talk a little bit about lawsuits. And I'll commend our friends at Law 360 for keeping up with these statistics. I know many of you, probably like myself, like to start the morning by reading and finding out what the Supreme Court has done lately or what's going on in the legal world. That's how I start my day every day. It's kind of interesting at times. We've noticed that the EEOC lawsuits have essentially plummeted in the first half of 2025. Law 360, they have a counter, and they say that the EEOC has filed fewer than 20 fewer lawsuits in the first 5 months of the Trump administration than it did during the same period back in 2024. Potential side effect of this, it's apparent that the EEOC right now is pulling back from litigation. Could also have to do with them not being at quorum. Some attorneys are seeing right to sue letters, allowing individuals and groups to go directly to court at a much faster pace, sometimes even within a week. I'll say I personally have not seen that, but other matters I had pending with the EEOC, I've noticed they've started to come out. EEOC lawsuits for the first 5 months, we've seen sexual harassment, which we're used to seeing, 3 religious discrimination, 3 disability discrimination, 2 pregnancy discrimination lawsuits, 1 age discrimination lawsuit,